pandemic and the health of the senators that are there, as well as health care has been an issue that they've brought up. Republicans are focusing in on the character and the resume of Barrett as they continue into day 3.
So, Kelly, it seems, they're trying to get at, especially the Democrats, at the judge's judicial philosophy. And at one moment, it seemed that Senator Leahy was a little bit frustrated, showing that he was frustrated by asking her about, is the president above the law?
Yeah, and he was also trying to get out, at least what we were seeing yesterday, a lot of senators, including Leahy, were trying to hear if she would recuse herself from any lawsuit or any case involving an election lawsuit after November 3rd. And they really didn't get a straight answer from her on that or other issues that were brought up. I know Senator Feinstein had brought up how she was frustrated she wasn't getting a straight answer, but Barrett's defense was that she really couldn't give an opinion or side one way or the other that would implicate how she feels in the matter.
Kelly, you've been continuing to watch this. I'm interested in your thoughts on whether or not senators are going to be swayed one way or the other during these 4 days of hearings.
We've been paying close attention to that, and I don't think there's going to be any senators up there that are going to be swayed. There could be, but it's more so, will the voters be swayed? Will people watching at home be swayed one way or the other because this is coming so close to the election? We're now 20 days away, so that's who we're looking at. I've noticed some polling that people are generally liking who Barrett is. Her favorability among Americans has gone up in the past few days, so she is presenting herself and presenting her case to the American people, and apparently they're responding favorably.
All right, Kelly, we got to cut you off. Senator Klobuchar is at the podium as this continues. Kelly, thank you.
And yet here we are stuck in a nomination hearing. I know what my constituents care about, what they've been calling and writing me about. And that is they are afraid of losing their health care in the middle of the pandemic. People's lives depend on the Affordable Care Act, like Steve, a senior from Tower, Minnesota, who has a heart condition and relies on his prescription medication. Emily from Minneapolis, mom was diagnosed with breast cancer. Janet from Rochester, whose brother has a mental illness. Or Christy, a mom from Bloomington, whose daughter had a tumor. That is what is on the line. Health care is on the line. And Judge, that's what's on the line in your nomination hearing, which unfortunately has been plopped in the middle of this election. This morning you had, I would call it an academic discussion with Chairman Graham about the doctrine of severability, and that's about if you can uphold part of a statute but throw out another part of it. And you correctly said there is a presumption to save the statute if possible. So I want to be really clear with the American people that the Trump administration's own brief, this is the position of the Trump administration, filed by the Trump Justice Department, says that the entire Affordable Care Act must fall. That is the position of the Trump administration going into this case that's going before the Supreme Court in a few weeks. Judge, you clerked at the Supreme Court. Does the Justice Department's brief that they have filed represent the administration's and therefore the president's position before the Supreme Court?
The Solicitor General is the government's advocate before the court.
Right.
Yes, that would represent the United States.
Right. And if the brief didn't represent the president's position, he would have the Solicitor General and the Justice Department withdraw the brief. Is that right?
I believe so, yes.
Okay. I just wanted to make that clear to the chairman and to everyone out there that while there is this doctrine to separate stuff and to try to uphold part of the statute, like maybe pre-existing conditions or doing something about keeping your kids on the insurance, the position of the Trump administration is to throw the whole thing out. The second thing I want to make clear is that you have been nominated to the highest court in the land, and you will be the deciding vote in many cases that will affect people's lives. And I appreciated that you've said it's not the law of Amy. It's not your law. But the point is that you will be in a really important position. I think that's one of the reasons that they're trying to ram through this process right now. And while you're not saying how you're going to rule on cases, as I said yesterday, I've been following the tracks, and the only way for the American people to figure out how you might rule is to follow your record and to follow the tracks. And we know this. You've said you consider Justice Scalia one of the most conservative judges in our nation's history as a mentor. You've criticized the decision written by Justice Roberts upholding the Affordable Care Act. In a 2015 NPR interview, you praised the dissent by Justice Scalia in another Affordable Care Act case, saying the dissent had the better of the legal argument. You signed your name to a public statement featured in an ad that called for an end to what the ad called the barbaric legacy of Roe v. Wade, which ran on the anniversary of the 1973 Supreme Court decision. You wrote your own dissent disagreeing with longstanding court rulings on gun safety, expressing your legal opinion that some felons should get guns, and you once discussed a dissent in the marriage equality case, asking whether it was really the Supreme Court's job to make that decision. So to me, these tracks lead us to one place, and that is that you will have the polar opposite judicial philosophy of Justice Ginsburg. And to me, that would change the balance of this court, which is already 5-4 and known as very conservative when you look back through history, to 6-3. 6-3. And that would have great repercussions for the American people. So I wanted to follow up on something that Senator Harris and I asked you about yesterday, and that is the issue of whether or not you understood the president's clear position on the Affordable Care Act before you wrote the article in which you criticized the legal reasoning for upholding the Affordable Care Act. The president tweeted just one day after you were nominated, that would be September 27th, that it would be a big win if the Supreme Court strikes down the health law. But before you were nominated, and this is what we showed yesterday, Donald Trump tweeted promising that his judicial appointments will do the right thing on Obamacare, unlike Justice Roberts. Yesterday, you were asked by Senator Harris, prior to your nomination, were you aware of President Trump's statements committing to nominate judges who will strike down the Affordable Care Act? You said, I can't really definitively give you a yes or no answer. What I would like to say is I don't recall hearing about or seeing such statements. And after she followed up, you said that the tweet wasn't something that I heard or saw directly by reading it myself. Okay, so I just want to go through some of the things that have happened over the last few years regarding the president's, his obsession to repeal Obamacare. He said, we will repeal and replace disastrous Obamacare when accepting the Republican nomination at the Republican convention in 2016. Did you see that speech?
At the Republican convention
in 2016. I'm not asking if you were there. I was asking if you saw it on TV.
No, I don't believe I watched any of the convention on TV. Or if
Okay.
I did, I don't remember any of it.
He has said things like, it begins, he wants to immediately repeal and replace the disaster known as Obamacare. He has said that he wants to get rid of it. He has said in States of the Union, I am calling on Congress to repeal it. He said, can you believe that Mitch McConnell, who has screamed repeal and replace for 7 years, couldn't get it done? So there have literally been hundreds of statements by him, by my colleagues, and I just find it hard to understand that you were not aware of the president's statements.
I am aware that the president opposes the Affordable Care Act. I'm aware that he has criticized the Affordable Care Act. I took Senator Harris's question yesterday to be referring to the specific tweet, maybe the one that you have behind you, about how he wanted to put a justice on the court to replace Obamacare. And I'm definitely aware of that tweet now. And as I said to Senator Harris yesterday, it came up in some of my calls with Democratic senators, brought it up. But I honestly can't remember whether I knew about it before I was nominated or not. I'm not sure.
But did you have then a general understanding that one of the president's campaign promises was to repeal the Affordable Care Act when you were nominated?
As I said before, I'm aware that the president opposes the Affordable Care Act.
Well, I know you're aware now, but were you aware back then?
Well,
when you were nominated?
Well, Senator Klobuchar, I think that the Republicans have kind of made that clear. It's just been part of the public discourse.
Okay, but is the answer yes, then, that you were
Well,
aware
Senator
of it?
Klobuchar, all these questions, you're suggesting that I have animus or that I cut a deal with the president, and I was very clear yesterday that that isn't what happened.
Were you generally aware of the president's statements when you wrote in an article in the University of Minnesota Law School Journal in 2017, the same year that you became a Seventh Circuit judge, that he pushed the Affordable Care Act beyond its plausible meaning to save the statue, that Justice Roberts had done that? Were you aware of that, of the president's statements when you wrote that article?
So that article, Senator Harris told me yesterday, was published in January of 2017. Okay. And a law review article takes several months to go into production. So I can't remember specifically when the conference was. That article came out of a conference for Randy Barnett's book. I can't remember when it was, but I suspect it was before the election. It's not like I wrote it in January of 2017.
But President Trump has been saying this in 2015, in 2016, and that's 2 years. It didn't take you that long to write the article. So my question is simply, were you aware of President Trump's opposition to the Affordable Care Act during that time?
Senator Klobuchar, I have no idea, and I suspect that if the article was published in January, that I wrote it sometime before the presidential election. And again, I want to stress, I have no animus to or agenda for the Affordable Care Act. So to the extent you're suggesting this was like an open letter to President Trump, it was not.
Okay. In the 2017 University of Minnesota Law School Journal that we just discussed, one of the things you said is there is a risk that a faction can run away with the legislative process, but there is also a risk that a faction will conscript courts into helping them win battles they have already lost fair and square. That's something you wrote in that article?
I did. I was responding to an argument made by Randy Barnett in his book, Our Lost No, I don't know if it was Our Lost Constitution or not, but yes.
So, I mean, that is what I'm afraid has happened here. They have tried 70 times, the Republicans in Congress, to overturn Obamacare. And now they're bringing this case to the court, and you are going to be sitting on the court. And so, and I find it very hard to believe that you didn't understand that when you wrote the article. So I want to, there's one other piece of this, and that is the effect on the economy. And we all know this has been very difficult. My colleagues know this. According to one Yelp study, more than 800 businesses have closed every day. 30 million people were out of work at the height of the pandemic. We're still down 10 million jobs. And so one of the things that's been going on here is we've seen more and more consolidation, and leading me to antitrust. And that part of this, I think, is the COVID relief package we have to pass, but also antitrust. Competition is a driving force of our economy. Justice Ginsburg, at her nomination hearing, described the Sherman Act as a broad charter. She said that free enterprise is the spirit of the antitrust laws, and the courts construe statutes in accord with the essential meaning that Congress had for passing them. Do you agree with her statement?
The Sherman Act is broadly worded, you know, insofar as it prevents combinations, contracts, combinations, and conspiracies in restraint of trade. And because that language is broad, courts have developed a robust doctrine of common law to enforce and bring about its promise of eliminating contracts, conspiracies, and combinations that restrain trade.
Yes, and I think you and I have discussed this before, but in recent years, Supreme Court opinions, by the way, all decided over Justice Ginsburg's dissent, have made enforcing our antitrust laws even more difficult. As a textualist, how would you reconcile the broad language of the Sherman Act with recent judicial precedent that has substantially narrowed the application of the statute in practice?
Let's see, I can say as a textualist how I would approach the Sherman Act. And in the case of the Sherman Act, you're right that it's broad language. The text of the Sherman Act, as the court has determined over time, essentially permits the court to develop a common law. So I think, you know, I haven't really had occasion to decide very many antitrust cases on the Seventh Circuit, but it's an area, because it's largely been left to judicial development, that is controlled by precedent for the most part.
It is, and that's my concern right now is that it has been so narrowed in its interpretation of the Sherman Act, the Clayton Act, that it's almost become impossible for people to bring those cases in any big way. I want to turn to something we talked about yesterday, which is elections. You worked on the recount in Florida that was related to the Bush v. Gore case, including on an absentee ballot issue on behalf of the Republican side of that case. Is that right?
I did work on Bush v. Gore. I did work on behalf of the Republican side. To be totally honest, I can't remember exactly what piece of the case it was. There were no
Don't worry,
challenges.
I'm not going to ask you that.
Okay.
We're in the middle of a global pandemic that is forcing voters to choose between their health and their vote. Are absentee ballots, or better known as mail-in ballots, an essential way to vote for millions of Americans right now?
That's a matter of policy on which I can't express a view.
Okay. That just, to me, that just feels like a fundamental part of our democracy. But, okay, let's try this. Have you ever voted by mail?
I can't recall a time that I voted by mail. It may be in college that I did when I was living away from home, but I can't, as I'm sitting here, specifically recall a time I voted by mail.
Do you have friends or family that have voted by mail or are voting by mail?
I have had friends or family vote by mail.
And you understand we're operating in a moment where the president is undermining vote by mail, even though a number of Republican governors and Republican senators are supportive of it. Many argue that Bush v. Gore, and back to your earlier work, hurt the court's legitimacy. If you are confirmed, the Supreme Court will have not one, not two, but 3 justices, you, Justice Kavanaugh, and Chief Justice Roberts, who worked on behalf of the Republican Party in matters related to the Bush v. Gore case. Do you think that that's a coincidence?
Senator Klobuchar, if you're asking me whether I was nominated for this seat because I worked on Bush versus Gore for a very brief period of time as a young associate, that doesn't make sense to me. I just think it's such a coincidence to me. I actually didn't know it until yesterday. But will having justices with this background, 2 of whom were appointed by the current president, decide any cases related to the upcoming election, do you think that will undermine the legitimacy of the court? Asking whether something would undermine the legitimacy of the court or not seems to be trying to elicit a question about whether it would be appropriate for justices who participated in that litigation to sit on the case rather than recuse. And I went down that road yesterday saying it's a legal question.
You said you wouldn't recuse. That's why I thought it was
That isn't what I said. I said I wouldn't commit. I wouldn't pre-commit.
You're right. You said you wouldn't announce your decision on recusal, and you wouldn't commit to recusing. But again, I think the public has a right to know that now 3 of these justices have worked on the Republican side on a major issue related to a presidential election. One thing I wanted to revisit quickly, Smiley v. Home. The reason I asked about that is that this would be unprecedented right now we're in an unprecedented time where we have a president who refuses to commit to a peaceful transfer of power, working to undermine the integrity of this election. And yesterday you wouldn't commit to recuse yourself from the case we just talked about, but now we're considering your confirmation to the highest court in the land in the midst of this election. And in Smiley v. Home, where the Supreme Court held that a governor is part of the legislative process, and therefore a legislature cannot unilaterally change election rules, that could be very important because we have a number of swing states where we have a legislature of one party, governor of the other. And we have this precedent that has been on the books for nearly 90 years. Do you think that that is established Supreme Court precedent? It said that a governor is part of the legislative process.
I actually am not familiar with that case, but it is precedent. Obviously, it's a precedent of the court.
Okay. I wanted to turn to one last issue, and that is First Amendment and freedom of the press, near and dear to my heart. My dad was a journalist. He would go everywhere for a good story and cared a lot about freedom of the press. And regrettably, our right to a free and independent press is under assault. We have witnessed unprecedented attacks on journalists and journalism in the past several years. Our president frequently uses his Twitter account to attack news organizations. He has accused the media of being fake news and called them the enemy of the people. Obviously, we also have journalists overseas that are under attack by dictators. I want to pay special tribute to those brave journalists whose dogged pursuit of the truth never wavered despite threats of imprisonment, violence, and even death. Journalists like Jamal Khashoggi and the men and women of the Capitol Gazette. Their legacy is proof that fear will not silence facts. The founders recognized that a free press is vital to a vibrant and strong democracy, and that's why we need Supreme Court justices who understand the importance of protecting the right of journalists. First Time v. Sullivan, you know that's a landmark ruling and with the support of the First Amendment protections for the press and protecting journalists unless they say something untrue with actual malice. Justice Thomas has expressed skepticism with that case, writing in his concurrence in McGee v. Cosby that if the Constitution does not require public figures to satisfy an actual malice standard in state law defamation suits, then neither should we. Do you agree with Justice Thomas that the court should reconsider the actual malice standard because it is inconsistent with the original meaning of the Constitution?
Well, Senator Klobuchar, I can't really express a view on either New York Times v. Sullivan or Justice Thomas's critique of it without violating the principle that I've repeatedly stated that all nominees follow, that, I can't comment on matters of litigation or grade precedents that the court has already decided.
I also want to ask you about how journalists have been deterred from doing their jobs under the threat of jail time. After the Supreme Court's 1972 decision in Brandsburg v. Hayes, many federal courts of appeals have recognized what's called the reporter's privilege, which protects a reporter's First Amendment right to protect his or her sources from disclosure in certain circumstances. The Seventh Circuit, by the way, on which you serve, has rejected a constitutional basis for a reporter's privilege. Under its original public meaning, does the First Amendment protect a reporter's decision to protect a confidential source?
Well, again, that would be eliciting a legal conclusion from me, which I can't answer in a hypothetical form in the hearing. It's also a question, as you point out, that's closely related to the ones that are being litigated.
Okay, one last try. Do you agree that if reporters cannot protect their sources, they are less likely to be able to find confidential witnesses willing to share information, confidential informers willing to share information about issues of public importance?
Well, Senator, that would both be a policy question, a matter of public policy, which I can't express a view on, and presumably also one that might factor into the question of what the First Amendment protects. So again, that's not something that I can give an opinion on in this context.
Okay. I guess my last thing I'll just say is I hope people watching out there are going to follow the tracks of this record and are going to vote. Thank you.
Thank you. Senator Sass.
Thank you, Chairman. Welcome back, Judge Barrett. Let's start with how judges should look back on their career at the end of it. So if you are confirmed, 30 or 40 years from now, when you hang up your robe and sit on a front porch in South Bend or wherever, probably with a big gaggle of grandkids around you, how will you judge whether or not you had a successful career as a judge and justice?
I would judge whether I'd had a successful career by whether I'd always acted with integrity, whether I'd always followed the rule of law and resisted the temptation to twist the law in the direction that I wanted it to go, whether I had treated my colleagues kindly and with collegiality, whether I had mentored, helped, and had good relationships with my clerks and any assistants or staff that I had, because both the law and the people are important.
And how would that differ from how a senator should look back on her or his career after hopefully not 30 or 40 years, but in my view, 12 would be a good limit. But how should senators look back on their career, and how does it differ from judges?
Well, let's see. So I probably can't say how a senator himself or herself would, but I'll say as a citizen how I might evaluate a senator's career at the end of it, and that would be to say, did he pursue good policy? Did he, sponsor legislation or vote for legislation that advanced the cause of the common good in the United States?
So I think when you corrected my question so that you didn't even pretend there was a hypothetical where you saw yourself as a senator, I heard both Todd Young and Mike Braun just have these huge gasps of relief at the thought that you're not going to be running for Senate from Indiana at some point. I think it's been clear in our conversations over the last 3 days that a number of us who are excited about your originalism and who believe the job of a judge is very different from the job of a policymaker, don't think that polling has any place in the questions before us at this point. But it is sort of hard to sit here after 3 days and hear claims made over and over again about how much the American people are opposed to you or whatever. So even though polling should have no place, just as a matter of correcting the record, I did happen to look up this morning, and the American people are overwhelmingly in favor of your confirmation. So just since this record seems to have been distorted so repeatedly with this idea that the American people are opposed to this, the public view of your confirmation is overwhelmingly in favor. I think it's plus 17 in the polling of this morning. But anyway, I certainly don't want you to comment on that. I'd like to transition to your writings a little bit. You, again, are a prolific writer. I think Justice Breyer is the only person currently sitting on the court that I can see that looks like he's written more than you have. And he's got a few decades of extra time as an adult writing relative to you. Can you tell us how you think your writing might change in the future? How will you pick venues, topics, audiences? What will you write about as a justice? Again, presuming confirmation.
Yes. So I would say, you know, most of my writing was during my time as a full-time law professor. The only thing I have published, I think, since being confirmed to the bench was I published a lecture that I gave at Case Western. And then I edited a transcript of remarks that, you know, I gave on a panel, but it wasn't like a full-length article with an idea. I found, frankly, that it's hard to manage, you know, all the demands of family life and the job and writing the kind of scholarly articles that I did in the past. If I remained on the Seventh Circuit and, you know, perhaps if I'm confirmed at some point in the Supreme Court, I would like to do more of that, but more in the vein of, say, what Justice Breyer does now, or what my colleague Judge Frank Easterbrook does, which is, you know, writing that is designed to kind of educate about ideas. I think Justice O'Connor's iCivics program, where she really, really set herself out to teach, you know, high school students and people in America about civics and how the civics process works. So I would see myself wanting to try to reach more general audiences. But if I have time, once my kids get a little bit older, maybe I'll dip back into scholarly writing again.
I think that's very helpful. I think it would be very useful if we had justices who did more of that civics education. You've named a few. I think there are some others over the last 30 or 40 years who've also done a lot of public civics education. I differ with Chairman and former Chairman Grassley of this committee about whether cameras would be a good idea in the court. Again, not asking you to opine on that. I'm glad we get the audio transcripts. I'm glad we have a lot of press that cover the court. I think we'd get a lot more Michael Avenatti nonsense if we had cameras in the court. I think we right now get a lot of transparency into the court, but we don't have as much theatrics from those who are arguing before the court. So I think more cameras in the court is a bad idea. More justices before the public explaining the structure of our constitutional system would be a huge asset. And given your history with Notre Dame students and law students, it seems like a natural fit for you. So for what it's worth, I think you have a lot of people who would encourage you to take up that civic calling. To tackle a few of those constitutional structure questions for a popular audience, can you explain what the Ninth Amendment is about? Why do we have it?
Well, it's often treated as a rule of interpretation. There's not a lot of substantive doctrine or any substantive doctrine under it. It's preserving. It says that, you know, the rights, that the individual's rights are preserved, that those not expressly granted aren't taken away.
And if we maybe broaden it from just the Ninth Amendment to the Bill of Rights in general, why do we have one, and what would be different in our constitutional structure if we didn't have the Bill of Rights?
If we didn't have a Bill of Rights, we wouldn't have particular rights singled out for special protection. As I'm sure you know, Senator, the Bill of Rights was added in 1791 because during the debate about the ratification of the original Constitution, many states objected to the fact that there was no Bill of Rights. The original idea, when the original Constitution, and by that I mean, beginning with Article 1, moving up, was that the very structure of government protected rights. And there wasn't thought to be a need to have a Bill of Rights because it was thought that the separation of powers and the structure of federalism would be a protection for those rights. But those who really felt like they wanted the additional protection of the Bill of Rights prevailed, and James Madison drafted them, and they were ratified in 1791.
So I don't mean to put words in your mouth. I mean to lay out a hypothesis so you can expand upon it or correct me. But is it fair to say that most governments in human history have had a default assumption of prohibition? Governments can do whatever they want, and citizens don't have rights unless governments proactively give them rights. The default assumption is you don't have freedom of religion in most governments across time and space. You don't have the freedom to start a business. And the American system starts with the opposite assumption, which is that freedom is the default condition. People are created in the image of God with inalienable rights. These are pre-governmental rights. And the government has to have specifically enumerated powers. We, the Congress, have to authorize Article 2 branch, the executive branch, to go ahead and do anything. And if they don't have those authorities, they in the executive branch and the administrative agencies, they can't do anything unless Congress gives them the freedom, and the people's default assumption is freedom. And so our system is to flip the historic prohibition assumption, and we have a freedom assumption on people and a prohibition assumption on government. And so prior to the Bill of Rights, the structure of the Constitution was saying that we don't need to enumerate rights because the assumption is you have a right unless a prohibition has been created. Is that a fair way to think about it? And how would you expand upon it more eloquently since you teach this stuff?
You are far more eloquent than I, Senator Sass. No, I think that is an accurate description of how of the assumptions underlying our Constitution. That the assumption was that if Congress had limited power, it wouldn't have the ability to infringe rights in the first place. And of course, at the time the Constitution was ratified, the states were thought to have, because the people are closer to their state governments, states, well, that's the point of federalism, right? That citizens can have different policies in states and more influence over their state governments and their state legislatures than the federal government.
What role does the Declaration of Independence play in interpreting the Constitution, or what's the relationship between the two documents?
Well, the Declaration of Independence is an expression of our ideals, expression of, our desire to be free of England. It's not law, however. The Constitution is law. So the Constitution is our foundational law and a governing document, and, while the Declaration of Independence tells us a lot about history and about the roots of our republic, it isn't binding law.
What are the 5 freedoms of the First Amendment?
Speech, religion, press, assembly, speech, press, religion, assembly. I don't know, what am I missing?
Redress or protest.
Okay.
Why is there one amendment that has these 5 freedoms clustered? Why do they hang together?
I don't know what you're getting at on that one. You mean, like, what is the common denominator?
Yeah, I mean, why I'm getting back to the same idea that the Bill of Rights was sort of an attempt to do public catechesis. It was an attempt to say, we already believe in limited government, we the founders. That's the brilliance of the miracle at Philadelphia, despite all the failures to live up to our ideals. But the 1787, 1788 conversation was to say, we believe in limited government because we believe in the limitless rights of people. And so they didn't have a Bill of Rights, but later when they started spelling it out, it's sort of like they got jazzed up trying to work this out for the American people. This is amazing stuff. And so I'm just wanting to hear you reflect a little bit on the glories of the First Amendment, even though it wasn't needed as a part of the structure at the beginning. Once they added it, why 5 of them in the same amendment?
I don't know why, actually, as a historical matter, those were grouped. I'm sure there's a story that I don't know there about why those appeared in the First Amendment altogether rather than being split up in different amendments. I mean, assembly and protest and speech bear more relation to one another than necessarily free exercise, say. But I think, they are in the First Amendment, and I think that reflects that those were core values, that reflects that the states who ratified the Constitution, the original Constitution, on the understanding that a Bill of Rights would be added, wanted protections like that to be included because they were really core to what the new Americans thought was going to be America.
Thank you. I agree with you, and I think that some of why it's so useful to think about the five together in my mind is because you don't really have freedom of religion if you don't also have freedom of assembly. If you can't gather with your co-religionists, you don't really have freedom of speech if you can't also publish your beliefs and advocate for them. You don't really have any of those freedoms if you can't protest times and seek the redress of grievances in times when government oversteps and tries to curtail any of those freedoms. And I think some of the important questions about judicial modesty in some of the last 3 days of hearings are very relevant and prudent to have had. But I also think there are times when there's been questioning that you've been put through that has implied that because you have free assembly rights as an individual, when you were a faculty member or as a wife and mom and neighbor in South Bend, when you signed something walking out of church, that sort of implied that there was something inappropriate, when the default assumption in our system is that we all have these freedoms because the civil society associations that we have are where we actually find happiness, meaning, joy, and love. I mean, one of the things that not just judges wearing robes need to have to demonstrate humility, but all of us in our day callings as public servants for a time, but who are eventually going to go back home to, the Cincinnatus language of George Washington's farewell address, to go back and sit under the tree at Mount Vernon, is that this is not the center of the world. This is not, the institutions of power are not where meaning is found. The institutions of power are about serving the people by trying to maintain a framework for ordered liberty so that the places where the 330 million Americans actually live can be the center of life and meaning and association and religion and speech and press. That the heart of our system is actually voluntarism, entrepreneurship, community, neighborliness, and love, and power is just in service of that. Washington and later Lincoln's expansion upon it was the idea of the silver frame, but the golden apple. The silver frame that is the constitutional structure is just to maintain the structure of ordered liberty so that people can pursue the good, the true, and the beautiful, the happy and the neighborly in the center of the picture, because that's where love and community is found. I'd like to pivot from constitutional structure to baseball for a minute, if you will bear with me. Any of your kids play baseball or softball?
Two of our boys had a very brief career in baseball.
Gotcha. Well, it's obviously not as great a sport as football, but we can still call it the American pastime. And I'd like to talk about the Houston Astros, who are miserable cheaters. Sorry, Cornyn and Cruz, but both of the Texas senators sit on this committee. But I think all baseball fans know that the Houston Astros cheat. They steal signs. They bang on cans. They've done a whole bunch of miserable things historically, and they deserve to be punished probably more than they have been. But tonight is Game 4.
Thank goodness the First Amendment protects that right for him to express that erroneous opinion.
If you want to defend cheating, that is certainly the prerogative of the senior senator. And the junior senator from Texas now rushes into the room to do some homerism.
It was going so well.
I noticed that Ted is wearing a Lone Star State flag, but not an Astros mask. Tonight is Game 4 in the American League Championship Series, and if Houston loses to Tampa, they will be done. And that leads people to feel kind of desperate at times, right? There are times when you have a game that's your elimination game. You can imagine people wanting to sort of reconsider anything they can reconsider. The ends might justify the means. And you could imagine that the Houston Astros, who've cheated in lots of ways in the past with sign stealing, might try to go to the umpire and try to persuade somebody to expand the strike zone just for Houston in the game tonight. That would obviously be inappropriate, right?
Right.
We can't have two sets of rules. Well, I think that an umpire is obviously supposed to apply rules fairly to both teams. I think we can all agree on that as rules of fair play. And I think some of what we've seen in the questions over the last 3 days are trying to get an umpire to commit to a different set of rules for different teams. And so for what it's worth, just to reiterate what I think so many of us have been trying to argue for in these hearings is the alleged equivalency between Republican and Democratic questioning here implies that Republicans have been trying to get you to pre-commit to certain policy outcomes, and I just don't think that that's actually what's been happening in this hearing. I think that the originalism that you've defended and that a lot of us have been advocating for in advance of and during this hearing is not a request for Republican policy positions to be advocated through the courts. It is rather a plea, not just to you and to future nominees, but to our Democratic colleagues as well, to embrace a system where we again distinguish for the American people between the two political branches and the apolitical branch. The fact that you were before us to be confirmed to a lifetime appointment where you will put on a black robe is a liturgical act where you're cloaking your policy preferences in humility. It is obviously the case that we're all shaped by life experiences. It is obviously the case that people have lived in communities in the past, and most people who end up as extraordinary jurists have been connected to or around the political process at different points in their career. But that is not to undermine the ideals we have in the American system that judges should not see themselves as super legislators. They should not see themselves as policy advocates. And they do have to take up this new oath to a greater humility. And it means that you lay down certain freedoms that are inalienably and innately yours prior to becoming a judge so that you don't have the appearance of bias and impropriety in the future. And so I want to reassert the idea that we should be trying to excise from our language this idea of conservative and liberal blocs on the court, Republican and Democrat justices. What we want, and I want this to not just be a Republican aspiration, but I want it to be a Democratic aspiration as well again. What we want are people on the court who understand with humility and modesty, the judicial role, because it is a limited role. It is not a role to right all wrongs in society. It is not a role to be a policy advocate. And I think you've comported yourself extraordinarily well over the last 3 days as you've been repeatedly asked to be an umpire who prejudges certain cases, and it isn't your job to do that until the reactive moment when you're actually on the court. So thank you for the civics lesson that you've offered Americans over the last 3 days. Thank you, Chairman.
Thank you, Senator.
Thank you. Mr. Chairman? Yes, here we go. Mr. Chairman, I was tempted to make a parliamentary inquiry if the unjustified broadside from the senator from Nebraska violates Rule 19 of this body. But I decided not to when I came to the realization that Nebraska lacks a professional baseball team and at times doesn't always have a winning football team either. And so I view it more as a plea for help than a substantive point. And I will say the remainder of the senator from Nebraska's questions and exchange with Judge Barrett I thought was excellent and a wonderful civic education for all Americans. The scurrilous lies about the Astros, I think, should be stricken from the record and forgotten by all.
Thank you. Mr. Chairman, I will later be asking unanimous consent to submit to the record a little bit of historical information about the Houston Astros, but we will wait for now. Thank you.
Can't wait.
Will you include a photograph of the World Series trophy?
I think there's an asterisk hanging over the trophy.
Well, number one, I want to thank Judge Barrett for not interrupting us during your hearing. Senator Coons.
Thank you, Mr. Chairman. Thank you, Judge. Good to be talking with you again. These questions of fairness and who follows the rules and who are the umpires and do we win at all costs or do we respect the traditions of the game are essentially what's before us. So let's get to it with the 20 minutes we have. And thank you again to your family and everyone who's traveled with you today. Judge Barrett, in accepting President Trump's nomination to the Supreme Court, you stated you share the judicial philosophy of Justice Scalia, your mentor, the justice for whom you clerked. His philosophy is, of course, originalism. Essentially, the idea that the authoritative meaning of the Constitution is what it meant when ratified, whether that was 150 years ago, 240 years ago, but meant when ratified. And I think the American people need to better understand what that originalist philosophy could really mean for their everyday lives, because I think it means our entire modern understanding of certain constitutional commitments around liberty, privacy, and equality under the law could in fact be rolled back to 19th or even 18th century understandings in a way unrecognizable to most Americans. Many of these modern notions are rooted in a landmark case decided in 1965, Griswold versus Connecticut, where the Supreme Court held married couples have the right to use contraceptives in the privacy of their own home. In an interview just 8 years ago in 2012 on Fox News, Justice Scalia said this decision was wrong because under his originalist philosophy, there's no such thing as a general right to privacy in the Constitution. This is a question most currently serving justices have answered. When we spoke on the phone last week, you said you couldn't think of any specific issue of law where you disagreed with Justice Scalia. Do you agree with him that Griswold was wrongly decided and thus states should be able to make it illegal to use contraceptives if they so chose?
Well, Senator, as I've said a number of times, I can't express a view, yes or no, A+ or F. In my other capacity, I get to grade, but not in this particular capacity with respect to precedent. I think that Griswold is very, 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 very unlikely to go anywhere. In order for Griswold to be overruled, you or a state legislature would have to pass a law prohibiting the use of birth control, which seems, shockingly unlikely. Right. And then a lower court would have to buck Supreme Court precedent and say, we're not following Griswold. Again, seems very unlikely. So I think that it's an academic question that wouldn't arise, but it's something that I can't opine on, particularly because it does lie at the base of substantive due process doctrine, which is something that continues to be litigated in courts today.
Well, just for the benefit of those watching, Judge Barrett, as I think you well know, your predecessors talked about Griswold in detail. Chief Justice Roberts said he agreed with the Griswold court's conclusion. He shared your view that he's comfortable commenting because it doesn't appear to be an area that would ever come before the court. Justice Alito, Justice Kavanaugh said essentially the same thing, that they'd agreed. In fact, Justice Kagan, who you've been citing on the no grading, said, I do, that she's willing to speak to it. And as every nominee has, I do support the result in Griswold. I understand that you're saying to us you're going to be your own justice and that you're very hesitant to talk about this case because it is an anchor to substantive due process. But let me just one more time say, are you unwilling to say, as so many currently serving justices have, that at least Griswold is not wrong?
I think Griswold isn't going anywhere unless you plan to pass a law prohibiting couples or all people from using birth control. And I think the question, because it's entirely academic, because it seems unthinkable that any legislature would pass such a law, I think the only reason that it's even worth asking that question is to lay a predicate for whether Roe was rightly decided, because Griswold does lie at the foundation of that line of precedent. Right. So because Griswold involves substantive due process, an area that remains one subject to litigation all over the country, I don't think it's an issue, a case that I can opine on, but nor do I think Griswold is in danger of going anywhere.
Well, and to be clear about what it underlies, it's not just that Griswold was a landmark case, as you well know. It anchors a lot of modern liberty interests in personal and family autonomy. It was extended to unmarried couples in Eisenstadt. It was extended to the right for women to control the reproductive choices in Roe and in Casey. But it was also extended to support same-sex couple intimacy in Lawrence v. Texas, and ultimately that same-sex couples have an equal right to marry in Obergefell. The reason I'm taking a few minutes with this is that Justice Scalia publicly disagreed with or dissented in each and every one of these cases. He wrote in one of these decisions that it reflected the court adopting the so-called homosexual agenda. And just last week, Justices Thomas and Alito issued an opinion stating the Supreme Court needs to fix problems from its holding in Obergefell. So I understand you'll be your own justice, and Justice Scalia's philosophy is significant, but I also think you've made it clear that it's largely your philosophy, and I'm trying to help viewers understand what it means to replace a Justice Ginsburg with someone who may more closely follow Justice Scalia's approach. If Justice Scalia had had his way, we'd be in a very different country with regards to gender discrimination. In one of Justice Ginsburg's most celebrated decisions in 1996, in the case involving Virginia Military Institute, she struck down their male-only admissions policy. Decades later, VMI honored Justice Ginsburg in recognition of the contributions its female alumni have made. Justice Scalia was the sole dissenter in that case and even accused the court of destroying VMI, which remains standing and strong to this day. Now, I'm just getting at how closely you would ally yourself with Justice Scalia's jurisprudence. Would you agree with Justice Scalia that Justice Ginsburg's decision in VMI was wrong?
Well, Senator Coons, to be clear, as I said, I think in response to this question yesterday, I do share Justice Scalia's approach to text, originalism and textualism. But in the litany of cases that you've just identified, the particular votes that he cast are a different question of whether I would agree with the way that he applied those principles in particular cases. And I've already said, you know, and I hope that you aren't suggesting that I don't have my own mind or that I couldn't think independently or that I would just decide, like, oh, let me see what Justice Scalia has said about this in the past, because I assure you I have my own mind. But everything that he said is not necessarily what I would agree with or what I would do if I were Justice Barrett. That was Justice Scalia. So I share his philosophy, but I've never said that I would always reach the same outcome as he did.
Understood. But I think a case like this is a striking example of what it might mean to replace Justice Ginsburg and her methodology and her approach with someone much closer to Justice Scalia. And frankly, to me, this comes back in part to the president who nominated you. President Trump did not nominate you to carry on Justice Ginsburg's legacy. He nominated you because he wants to undermine or change or shift that legacy. And he's been very clear repeatedly before you were chosen about his intent to nominate justices in the mold of Justice Scalia. You recognized yesterday in an exchange with Senator Leahy that replacing Justice Scalia with Justice Garland, had Judge Garland become Justice Garland, would have changed the balance of the court. It's something you wrote about in 2013 in the Texas Law Review. You recognize these balance shifts are why Supreme Court nominations are so much at issue in presidential elections. Do you just acknowledge that your confirmation, even though you won't be identical to Justice Scalia, will profoundly impact the balance of the court and the way in which it decides future cases?
I think the statement that I was having an interchange with Senator Leahy about yesterday was about an interview that I gave shortly after Justice Scalia's death, but after Judge Garland's nomination. And I did say that, use that phrase, lateral move. And what I meant by that, I mean, I very much agree with Senator Sass that we shouldn't talk about Republican judges and Democratic judges because I think there are just judges. But of course it's true that judges have differences in judicial philosophy. So I actually think Justice Breyer and Justice Scalia are a great example of this because they sometimes had public debates with Justice Scalia advocating originalism and Justice Breyer advocating active liberty. And there's room on the court for that, for having different approaches. It's not about having, you know, your colleagues on the other side of the aisle, you know, all of you in the room have different policy platforms, but judges don't have policy platforms, but it is certainly the case that judges take different approaches to interpreting the text. And that is what I meant when I was describing how the balance of the court would shift. It would be away from one balance and toward another in terms of how judges think about the text.
And Judge, what I want to explore with you in the time I have remaining is exactly how those shifts in methodology, in approach, may well have a dramatic impact on the policy outcomes, on what is and isn't upheld as law going forward. On the board behind me, I've asked my team if we would just go back and look at cases. All of these cases listed, it's roughly 120, have something in common. Justice Ginsburg was in the majority, Justice Scalia was in the minority dissenting. And these are cases that touch on nearly every aspect of modern American life. I've talked a lot yesterday about health care and the Affordable Care Act. Yes, that's on there. A number of my colleagues have talked about some other areas. But what's striking is if you just look at what a 5-4 balance towards this methodology means if changed towards a 5-4 balance to this methodology, it has huge consequences for education, for consumer rights, for access to the courts, for civil rights, for immigration, for environmental protection, for Native American rights, for workers' rights, for elections, for executive power, for reproductive rights, for free speech, civil justice, economic development, privacy, government misconduct, prisoner rights, capital punishment, gun safety, and criminal justice. In each and every one of these cases, if Justice Ginsburg had been replaced by a justice with the same core methodological approach and view of the law and decision-making, you can't predict exactly how the case would have turned out, but in virtually every case, it would have moved in a different direction, and in a direction much closer to Scalia's philosophy and farther away from Justice Ginsburg. And that's why I think your views on precedent matter, and we should take a few minutes and go through them. It's something you've written about at length and where you're quite well-grounded. The precedents of the court, which is what these 120 cases are precedents upon which litigants, the average American, should be able to rely. And that's that whole issue about whether justices are simply umpires calling balls and strikes or whether there is some agenda. My concern is that a leading scholar in the field of constitutional law has recently reviewed your writings and concluded that you demonstrate an extreme willingness and even radical willingness to revisit settled precedents. Some characterize you as more extreme than Justice Scalia in your approach to precedent and closer to Justice Thomas. The Supreme Court has long held, as you well know, that overturning precedent, a settled case, requires a special justification or strong grounds. But in a 2003 article in the University of Colorado Law Review, you wrote, and I'm quoting, and I think I'll get a chart here in a second that has this quote, "Generally speaking, if a litigant demonstrates a prior decision clearly misinterprets the statutory or constitutional provision it purports to interpret, the court should overrule the precedent." What I see missing from this text and the broader context around it was anything about needing a special justification to overturn settled law or anything about the other factors the Supreme Court typically requires. You seem to be saying a judge should overrule any precedent as long as she thinks it's clearly wrong. If that's your view, and I think from this text it is, it basically means any precedent is at risk where your originalist view of the Constitution or textualist view of the statute says it's clearly wrong. Do you stand by this statement?
Senator Coons, that statement was talking about the courts of appeal. I believe that statement was about the due process clause, and as you probably stretch back from your lawyer days, remember the principles of issue preclusion and claim preclusion. Right. And that article was about how in the courts of appeals it had a very rigid rule that one panel couldn't overrule another, that those rigid rules in the courts of appeal were inconsistent or in tension with some of the court's issue and claim preclusion doctrine. So it wasn't about normal functioning of precedent, especially at the Supreme Court where there are no such rules. And I'll point out that the article was about circuit courts and courts of appeal, and in my time on the Seventh Circuit, I don't think there's any evidence that I've been unwilling to follow or apply circuit precedent. As for this scholar criticizing me as a radical on Starry Decisis, I'm not sure who it was or the substance of the criticism, but I'm very surprised because I think it was my conversation with Senator Feinstein earlier. I explained that the article, which many people have plucked a sentence from, the Texas Law Review article, was a defense of the Supreme Court's approach to constitutional stare decisis.
Well,
And
if we can, let's move to that quote, because your words weren't just limited to this context, to talking about individual litigants versus how issue preclusion works. It was a novel analysis, the 2003 article, something I hadn't thought of about how stare decisis impacts an individual litigant. But in this 2013 University of Texas Law Review article, which has also been referenced today, you wrote, and I'm quoting, "It's more legitimate for a justice to enforce her best understanding of the Constitution rather than a precedent she thinks clearly in conflict with it." Again, you're saying that if a Supreme Court justice thinks a prior ruling was clearly wrong, she should disregard precedent with which she disagrees, regardless of the typical balancing factors.
Senator Coons, with respect, as I explained this morning, that sentence has been plucked out of the article to kind of, I think, create a misimpression about the context. The whole article discussed reliance interests, discussed the reasons for stare decisis, and emphasized that courts ought not disrupt settled precedent, absent very good reason to do so, reliance interests being one. And I think that no one on the court, or even no one in this room, would think that the court ought never revisit its precedent. As I was mentioning, maybe it was to Senator Leahy earlier, you know, Bowers versus Hardwick held that certain sexual conduct between same-sex partners was illegal. It was criminalized. And then Lawrence versus Texas overruled that. And my guess is that you think Lawrence versus Texas was correctly decided. So I don't think, Senator Coons, that your position would be that no precedent should ever be revisited.
Correct. I do think in grievously wrong cases, it is appropriate to reach back, as a number of members have discussed around Brown versus Board and Plessy, and I did note that exchange earlier. But in terms of reliance interests and the significance of reliance interest, in reading that 2003 Colorado Law Review article, you wrote that reliance should count much less, if at all, when a litigant convinces a court that precedent conflicts with the statutory or constitutional provision it purports to interpret. I was struck by that language because I know you choose your words carefully. You've acknowledged reliance interests exist and they're part of the Supreme Court and its approach. But in this article, it seems to me you're giving your own views about whether reliance should matter. And you're unequivocally stating it shouldn't. It should matter less, if at all, when the originalist approach to reading the Constitution says this is wrongly decided. That's why, to me, the concern about reading the Constitution through a Scalia lens rather than a quite different, methodologically, Ginsburg lens. You've also recognized originalists like yourself are more likely to overturn precedent. In the Texas Law Review article, you cited statistics that self-identified originalists like Scalia and Thomas urged and joined in overruling precedents more than any other justices over an 11-year period. The disturbing picture to me overall about all of this, about precedent, is that I think there's been a movement amongst originalists and a change in terms of the approach of judges to judging who self-identify as originalists. In the 2017 article in the University of Minnesota, in Constitutional Commentary, that's been referenced before, you said, and I'm quoting, about modern originalists, that they've abandoned the claim one should be an originalist because originalism produces more restrained judges. Do you stand by that characterization?
Well, Senator Coons, I just want to point out that in this whole discussion, you know, I did write that Colorado article in 2003. I don't recall that sentence or its context, but in my full body of work, including everything that's come before, including the 2013 Texas Law Review article, I've written at great length about the virtues of stare decisis and the stability interests it serves. And in my scholarship, I've also talked about other features of the judicial system. And also, I'd like to point out that nothing in my record in the Seventh Circuit shows disrespect for stare decisis. And also, Justice Scalia did observe and follow precedent. It's not like Justice Scalia ever advocated an overthrow of stare decisis. So I just don't think there's any evidence to suggest that I'm in there trying to burn up the 600 volumes of the United States reports that are on the shelf. I don't have an agenda in that regard.
Well, that's so exactly what caused me concern as I looked at Thomas versus Scalia, and which may be more the role model you follow in terms of the application of stare decisis. These quotes jumped off the page. I haven't made a practice of reading 50-page law reviews recently. I don't mean to suggest
recommend it.
they were compelling and well written. But these quotes struck me as clear statements of a view or an intent. And as I've said before, the larger challenge here is not what you've said about your views on cases, but what the president who has nominated you has said about his goals and his objectives for your service on the court. And frankly, my concern about originalism and an activist willingness to reconsider precedent is that in combination, Justice Scalia's views, often expressed in sharply worded, memorable dissents, may make for great academic reading, but I think most Americans don't expect them to become the law of the land. And in a long line of cases, they would overturn well-settled precedent that I think we have all come to expect. So my core concern here, Your Honor, is that your confirmation may launch a new chapter of conservative judicial activism, unlike anything we've seen in decades. And the point of the chart was to just show we've mostly been talking about the Affordable Care Act and privacy-related cases. But if that's true, it could touch virtually every aspect of modern American life. I pray that I'm wrong. I hope that I am. But in my reading of your work, nothing has alleviated my grave concerns that rather than building on Justice Ginsburg's legacy of advancing privacy and equality and justice, I'm concerned, in fact, you will take the court in a very different direction. And so with all due respect, I will be voting against your confirmation, Your Honor. Thank you, Mr. Chairman.
One brief comment. The 6 super president cases, how many were there? 5, 6? I don't know.
Oh, let's see. This is going to be just like when Senator Sass asked
Well,
me
we
how
know
many
where they're at.
There was Marbury, there's Brown, there's Mapp versus Ohio, there's the civil rights cases.
So just very briefly for the public. And the reason those cases were picked by you, nobody is suggesting in today's world that it's not the Supreme Court's decision to interpret the Constitution, Marbury versus Madison.
That's correct. And to be clear, that list was formulated by other scholars.
Right.
I was referring to it. But
Not
yes,
just your list.
Nobody thinks that Marbury versus Madison and the court's authority to interpret the Constitution.
And nobody in America is wanting to go back to segregation. No legislative body is attempting to do that for a good reason. America does not want that. Nobody in their right mind wants that. The rest of these cases that have been listed as super president have that commonality, overwhelming acceptance. Is that correct?
Yes, that is correct.
As to Roe and Casey and to Heller and to United Citizens, active litigation going on right now today. Is that correct?
That is correct.
Senator Hawley.
Thank you, Mr. Chairman. Judge Barrett, good to see you again. Are you aware of any active litigation challenging the constitutionality of Griswold versus Connecticut?
I am not.
Are you aware of any litigation in recent decades challenging the constitutionality of Griswold versus Connecticut?
I am not.
Are you aware of any legal movement out there to challenge the constitutionality of Griswold versus Connecticut?
I am not, although Senator Hawley, as I said to Senator Coons, I'm certainly not aware of anybody trying to make the argument that a legislature should prohibit the use of birth control. But as you know, Griswold does lie at the base of the doctrine that very much is challenged in federal court.
Here's my point. I was 7 years old when Judge Robert Bork came before this body. I don't remember any of that. I wasn't watching it as a 7-year-old. But what we saw, I think the legacy of the Bork hearings continue to reverberate. His name has become a verb, the borking of nominees. I think what we've seen today is an attempted borking of Judge Amy Barrett. The problem is they don't have anything in your record that they could use to so badly misconstrue, to suggest that you're somehow going to fundamentally change America, that now they have to attribute to you the worst readings and most draconian misinterpretations of Justice Scalia. So we take Scalia's record, we distort that, and then we attribute it to you. So let me just come back to your relationship with Justice Scalia. I was under the impression that you were a different person than Justice Scalia and that you had, in your own words, your own mind. Is that fair to say?
That is fair to say.
Is it fair to say that you are an independent woman and an independent jurist and an independent professional and also, by the way, a pretty darn good lawyer, and you'll make up your own mind on the decisions, cases, controversies that come before you to the Supreme Court of the United States? Is that fair to say?
Yes.
I think maybe then we can put to rest this attempt to constantly leverage the worst interpretations of Justice Scalia's philosophy, misrepresentations, and attribute them all to you as if you are the same person. Frankly, I think it is demeaning and insulting. And I'm glad that you pointed that out in response about your independence to the last question. Let me ask you about another set of questions, just briefly, you had this morning. Senator Leahy asked you about the Foreign Emoluments Clause, which is in Article 1, Section 9, Paragraph 8. He asked you whether it was best characterized as an anti-corruption clause. You might remember that, in terms of foreign influence and foreign interference. And then he referenced the president and various allegations about foreign influence. Since he asked you about it, and since he asked about foreign influence in government, I think it's only fair that I ask whether, hypothetically speaking, just hypothetically, if there were, let's say, a vice president of the United States who hypothetically had an adult son, who hypothetically worked for a foreign oligarch, who then sold access to his father, the vice president, and his father then intervened in a case to make sure that that oligarch wasn't prosecuted, hypothetically, would that constitute the kind of foreign corruption that the Constitution's concerned about?
I can't answer hypotheticals.
Well, I thought you might say that, and I'm glad you don't and won't, because who knows, that case may come before you, but I think it's a fair set of questions to ask. Let me ask you about something different. Section 230 of the Communications Decency Act, passed by Congress in 1996, yesterday, Justice Thomas issued a dissent from a denial of certiorari in a case called the Malwarebytes case. Now, I bet you haven't had a chance to see his.
I was just about to say, please don't ask me about it, Senator Hawley, because I didn't have a chance to read anything.
Well, let me read to you just a few parts of it. It's quite significant, I think. Here's from the opening paragraph. When Congress enacted the statute, meaning Section 230 of the Communications Decency Act, most of today's major internet platforms did not exist. And in the 24 years since, we have never interpreted this provision, we meaning the Supreme Court. But many courts have construed the law broadly to confer sweeping immunity on some of the largest companies in the world. He's talking about the big tech companies. And he quite methodically, over 10 pages, goes on to set out the ways in which courts, at the behest of these tech companies, have dramatically rewritten Section 230, changing its liability standards. He talks about changing the distinction between publisher and distributor liability, changing the immunity shield, changing the narrow liability shield, extending 230 to protect companies from a broad array of traditional product defect claims. He says it's quite a thorough statement. Here's my question to you. You haven't read this. I don't think you've had a Section 230 case.
I haven't.
So in general, not about his dissent from denial, but in general, what are the dangers of the Supreme Court or any court rewriting a statute, departing from the text that Congress or a legislature, a lawmaking body, departing from the text they have written, that has been adopted, presented and adopted? What are the dangers in that if a court departs from that and substitutes its own judgment, whether it's done in one opinion over a series of years?
So, as you've posed the question, without respect to Section 230, just in general, the danger of a court doing that is to subvert the will of the people. You represent the people, as has been pointed out over the course of the hearing. Judges are not elected, and they have life tenure and can't be voted out of office. So, if judges misconstrue statutes or bend them to the judge's idea of what would be good public policy, then it deprives the people of the chance to express the policies that they want through the democratic process.
And the effect can be cumulative, can it? I mean, you can start with a change to the statute, a rewrite of one provision of the statute that then becomes precedent, and then when the court revisits this case later, revisits the issue later, then they expand that and do a little more rewriting, and pretty soon, 5 or 10 or 15 years later, you're with something that has been so heavily blue-penciled, so to speak, that it doesn't bear much resemblance at all to the original statute. I mean, that's a danger of courts continuously substituting their own judgment. Is that fair to say?
That can happen.
So, let me just say, my opinion, not yours, I think it's pretty clear that has happened with Section 230. I think Justice Thomas does an outstanding job here of laying out why that's the case. Let me ask you in a related vein, Justice Holmes, Oliver Wendell Holmes Jr. said in the famous Lochner case, in his famous dissent in that case, over a century ago, he said the 14th Amendment does not enact Mr. Herbert Spencer's social statics. Do you agree with that statement? Well, what do you think he was getting at with that?
So Justice Holmes' famous dissent in Lochner, which was later the position adopted by the court, is that, you know, courts shouldn't pour their ideas of good economic policy into the 14th Amendment to stand in the way of policies that the legislatures enact, for example, on questions of maximum hours for bakery workers or minimum wages and those kinds of things.
You mentioned economic policy. Talk to us a little bit about how a court could substitute its own views on economic policy for those of a law enacting body, of a legislature or of Congress.
Sure. Well, in that era, you know, in the Lochner era, and then we saw it also in the cases that preceded the switch in time, the court was standing in the way, I guess in Lochner itself, in the way of reforms for workers that legislatures were enacting. And so if, say, one had a preference for free trade, or if one had a preference for having no minimum wage or having a minimum wage, to hold such a statute that did the opposite of your policy preference unconstitutional because it didn't comport with your idea of the best economic policy would be to thwart the will of the people without warrant in the Constitution.
Are there dangers in courts acting as, let me preface this by saying, most judges are not economists. I suppose some may be, but most judges are not economics experts. Are there dangers in general with courts acting as economic policymakers, deciding economic policy, making economic judgments? I mean, is that something that courts should be wary of as outside their area of expertise?
Well, I am certainly not an economist. I think courts are expert in interpreting law. You know, we've been trained in law schools, and that's what we're good at, and that's what we should stick with.
I raise these concerns, and I raise them in conjunction with Section 230, because it seems to me that in the closely related antitrust context, we have seen over a period of many years courts substitute their economic judgment in many cases for what the words of statutes actually say and what perhaps the fairest interpretation of statutes might actually be. And whether it's Section 230 or the antitrust laws, one effect of this is to see growing concentrations of power in this country economically that I think are very significant threats to the ongoing operation of our democracy, to the basic ability of the people to control the levers both of the economy and of culture and of government. And I'm afraid I think that courts have some role in this in much the way that Justice Thomas suggested in his dissent from denial yesterday. And I think it's hard to ignore it in the antitrust context as well. So I won't ask for your view on this because these are cases, these are issues that you may well be called upon to weigh in on. I hope that you are. But I hope that you will give these issues consideration and the I think very well taken warning of Justice Holmes in Lochner. I think perhaps that insight has been lost sight of in many cases by both Republican appointees and Democrat appointees over many years on the Supreme Court in a variety of areas. Let me transition to one other area of law that's very important, back to the First Amendment and to the free exercise of religion. You had an interesting free exercise case recently. You were on the panel. You didn't write the decision. This is the Pritzker case. Illinois Republican Party versus Pritzker, decided on September 3rd of this year. So it's quite recent. It was just last month. This is a case in which the governor of the state was sued because, in the words now of the opinion I'm quoting, his executive order relating to COVID lockdowns, quote now, exhibits special solicitude for the free exercise of religion. And the case, in a roundabout way, challenged that special solicitude for churches and religious organizations. You joined the opinion in full. You didn't dissent. Can you say why you joined the opinion and why you think that the content here is right, why the holding is correct?
Sure. So in that case, the Illinois Republican Party said that because the executive order in Illinois had given an exception for the free exercise of religion, for example, so that people could gather at churches or synagogues or mosques, that same special protection had to extend to the Illinois Republican Party and indeed, by logical extension, to everyone, so that the whole order would fall, because religion couldn't be singled out for special treatment. and that right to free speech, free assembly, et cetera, that it was, under First Amendment doctrine, a content-based distinction that could not survive. And what that opinion said about that is that it was permissible for the governor of Illinois to carve out an exception for free exercise, and that doing so didn't compel the government to extend the same protection to everyone. As Judge Wood said, very well in that opinion, trying to accommodate a right explicitly mentioned in the Constitution and the First Amendment did not put the COVID order in jeopardy.
And the opinion is very firm on this point. You quote from the Hosanna Tabor case, which you and I discussed a little bit yesterday, unanimous case from the Supreme Court. This is the opinion quoting from that case. The First Amendment itself gives special solicitude to the rights of religious organizations. That's the Hosanna Tabor case. This opinion that you joined goes on to say there can be no doubt that the First Amendment singles out the free exercise of religion for special treatment. Rather than being a mechanism for expressing views, as the speech, press, assembly, and petition guarantees are, the free exercise clause is content-based, as you just said. The mixture of speech and music and ritual and readings and dress that contribute to the exercise of religions the world over is greater than the sum of its parts. In other words, what I understand, correct me if I'm wrong, what I understand the panel to be saying is the free exercise of religion isn't reducible to the free exercise of speech. It isn't reducible to the free exercise of assembly. Those are important rights. Those are also protected by the First Amendment. But the free exercise of religion protects something different and more. It protects the rights of religious people and religious organizations of all backgrounds the world over, but of course in this country, for Americans, it protects them and gives them special solicitude under the First Amendment. Have I got that correct?
Yes, to be clear, I can't take credit for the eloquent language. That was Judge Wood's language on the panel opinion that I did join. Yes, but the point that the panel opinion makes is that the free exercise of religion is singled out for its own protection in the First Amendment rather than being a subset of speech. And the position that the Illinois Republican Party took in that case would have been more putting everything under the speech umbrella.
And why do you think that is an important point of constitutional law? If I could ask you to put on your, I'm not asking you how to comment on cases, but if you could put on your constitutional scholar hat, why is it significant that the First Amendment gives special solicitude, as this decision says, as the Supreme Court has repeatedly said, special solicitude to the rights of religious associations, religious believers, religious worship and exercise?
I think that case itself, the Illinois Republican case, shows why this distinction can matter, because as our panel held in that case, the outcome may have been different if we had been treating it solely as a free speech question, because the court has said that content-based distinctions, under the First Amendment, get strict scrutiny and it can be hard to satisfy. So the case might have come out differently had it only been speech at issue. The case came out as it did because free exercise was also at issue.
I think in this time when we see many challenges to the rights of religious organizations, their ability to meet freely, and where frankly we see many instances around the country where religious organizations are treated, religious churches, synagogues, mosques are treated less favorably than secular counterparts, whether that's casinos or gyms or liquor stores, you name it. But so many different executives around this country have chosen to single out churches for disfavor, whether it's in the COVID context, which is what this case is about, or another context. I think that the holding of this opinion is very, very significant, and the Supreme Court's doctrine on this line of cases about the rights and the special solicitude, in the court's words, for religious organizations is very, very significant. I'll just conclude by saying, Judge Barrett, that it's been a privilege to get to speak with you these last couple of days. Congratulations to your family and to Jesse, and I think you have been, your answers to these questions have been really, really exceptional. I have been extremely impressed, and I was impressed to begin with. And I just want to put a finer point on something that Senator Sass said earlier. He said, you exercised your rights of assembly and free exercise and free speech when you were a faculty member. We've talked about that at length, various positions you took, and he pointed out there's nothing wrong with that. You shouldn't be penalized for it. I just want to agree with the chairman that I think there's nothing wrong with confirming to the Supreme Court of the United States a devout Catholic pro-life Christian, and it will be my privilege to vote for you.
Thank you.
Thank you, Judge Barrett. Thank you, Mr. Chairman.
Senator Blumenthal.
Thanks, Mr. Chairman. Welcome back, Judge Barrett, and to your family as well. I hope you got some rest last night. I think that's true of all of us.
So I did have a glass of wine. I'll tell you that I needed that at the end of the day.
Well, let me just say on that kind of point, you have a right to remain silent. First, Mr. Chairman, I'd like to enter into the record some letters from the National Council of Jewish Women and 86 Jewish organizations, from gun violence prevention organizations, and from the pro-choice caucus.
Without objection.
Thank you. There are a couple of loose ends that I'd like to clarify from our conversation of yesterday. First of all, in our discussion of the Second Amendment, we both made reference to the Third Circuit and its ruling on whether or not individuals convicted of a crime could possess a firearm. And I think you cited the Third Circuit as supporting the idea that certain felons could possess firearms, if I'm not mistaken.
And I went back and checked that too. And so you're right, it was a splintered decision. And I was thinking of Judge Hardiman's opinion, which was close.
Let's try to correct the sound system. Okay. I hope my time is restored. We will protect all of your time. Thank you.
Welcome back into the NewsNation Now digital studio. A little bit of technical difficulties, so as they continue to work that out, and we are in an age and time right now where technology no doubt can fail. Amy Coney Barrett in this confirmation hearing, kind of waiting to see what's going to happen here, whether it's a microphone issue or what's going on.
Well, she was answering a question. It
looks like we are going to take a break here.
Okay. Senator Richard Blumenthal was just started his 20 minutes, and then her audio went out. And then it was funny, Aaron, because you and I were checking to see if it was us or if it was there, and it was there for sure. And they acknowledged that they were having some audio issues there.
Well, this comes right after kind of a real moment from the judge. She admitted to Senator Blumenthal that she had a glass of wine last night after what was a very long day yesterday, well into the evening last night. We're going to kind of get our ducks in a row right here. We're going to reach around for a moment. I know Jean needs to slip on that microphone.
Yes, I sure do.
But we're going to be here and kind of fill in until, reaching over here to get a computer. We're going to fill in until we know that everything is okay there. Again, now you can see on your screen that we actually have taken a recess. We assume it's going to be about a 15-minute recess, which is something that is normal in a recess like this.
And it isn't the first technical difficulty we've seen. We actually, I don't know, is she speaking? Oh, okay. This is actually some footage that we have from earlier that we're rolling right now for you. But we did notice that it was yesterday or the day before on Monday they were having some issues with the video as well. So it's nice to know that during the pandemic everyone's had some sort of technical difficulty, even the Senate.
So we have been taking notes. That is, again, one thing that is trending right now on social media is that Amy Coney Barrett doesn't need to take notes because she has an empty notebook, but kind of going through some of the more memorable moments from the afternoon session.
You know what, Aaron, I know that you wanted to update. You had mentioned before the start of this streaming section that we had mentioned Lindsey Graham's comment.
That's a great point. So Lindsey Graham earlier when he began had mentioned the good old days of segregation. He did take a moment in the afternoon session to say that everyone agrees that segregation was wrong and we didn't need to go back there. So I think that in the lunch break he may have been told, find a moment to fix that.
And he did tweet, he said basically that it was the equivalent, he misspoke, that's not what he intended. And to give you a little bit of context about that phrase and that statement, he was really trying to talk about what's set as super precedent versus just standard precedent. And so they were talking about Brown, the landmark case Brown, of course, that ended segregation, separate but equal in schools. So that's why he was mentioning the days of segregation.
All right, 22 senators will have the opportunity to speak for 20 minutes each, asking questions of Amy Coney Barrett. A lot more questions we've seen today. Right now we are at Senator Richard Blumenthal from Connecticut. We've got, let's see, one.
He's the 14th.
He's the 14th,
senator so
we
far
got
today.
8 or 9 more. 1, 2, 3, 4, 5, 6, 7, 8, 9 more. Make sure my math is right. Count those out. But we do have some that are going to bring maybe a little bit more hard-hitting questions, if you will, for the judge, including Cory Booker out of New Jersey. Joni Ernst has gotten a lot of play. She's in a very difficult battle right now in her home state of Iowa, as well as the vice presidential candidate Kamala Harris will be later this afternoon.
Wanted to mention, you're talking sort of a more narrowing of focus in terms of the questioning today. I think a lot of senators spent yesterday using their 30 minutes to sort of outline what they plan to discuss, what they plan to question Judge Coney Barrett on, and I think today they are going directly to those questions, most of the senators.
All right, as we continue to stall for some technical difficulties there, Joe Khalil is working with us to get in from Washington, D.C. to kind of chat about what he has seen so far this morning and this afternoon. He is our NewsNation Now Washington correspondent. Joe, are you with us? No, we don't have Joe just yet. We're still working to get him.
Well, I wanted to go over a couple of the senators and sort of what they were trying to focus on. I know with Amy Klobuchar, who actually talked at length on Monday sort of about how COVID-19 had affected her family. I think she said that her husband had been in the hospital with COVID-19, had to receive treatment for that, as well as I think some extended family members as well. She started off this session after the lunch break, and she basically was talking sort of about, also mentioned the free press when she was talking to Judge Coney Barrett.
Yeah, I think that is interesting as well when that was brought up. And Coney Barrett, again, as she has done, has not really taken a lot of or answered a lot of those questions based on basically law that she doesn't know, cases she hasn't heard. She is really stuck by that fact that she wants to make sure that if she answers a question based on anything, she has done the studies, the writings, and the readings on those cases.
Obviously a brilliant legal mind, also a very well-liked professor when she was a tenured professor at Notre Dame Law School. And just to give you a sense of how agile Judge Coney Barrett has been in terms of answering questions, when Senator Coons from Delaware was trying to get an answer from her about sort of precedent and predicate, she was really able to kind of work her way around it and say, I think you're asking me this question so that you can lay a predicate to ask me about Roe v. Wade, and very much decided. Actually, I think are we back up or?
All right, so let's go now live to Washington, D.C. Joe Khalil joins us now, our NewsNation correspondent. Joe, you know, this is kind of one of those situations where we knew something like this would happen. Technical difficulties there in the Senate committee room.
Yeah, you get an unexpected thing like that. You know, certainly those things happen. I imagine that they'll, you know, wrap that up and fix it for whenever they come back. So, guys, I should say right off the bat that Senator Whitehouse, who was a big part of yesterday's hearing and then spoke again earlier today, and really I thought gave an effective testimony and questioning. He is going to be here, and we're going to be doing an interview. So I may have to cut away at some point. We can certainly ask him if he wants to join us, and maybe he'll, you know, we can throw a question or two at him directly as we're doing this.
Joe,
yeah, go ahead.
I wanted to follow up. You just mentioned Senator Whitehouse, and it seemed that he, yesterday he was really talking about sort of dark money and funding, and today he talked about ethics and finance reform with the judge, and it almost seemed that he acknowledged that this was inevitable, that she was going to be confirmed, and sort of said, hey, look, I know you're going to be sitting on the Supreme Court soon. These are some things some topics that I want you to look out for.
It was interesting. I think he called it out, and it's certainly something that everybody in the room, I think maybe if they're not expressly talking about it, then it's something that is well understood, right? That at this point, sort of an inevitability. Even Senator Graham, in the opening on Monday, called it out and said we're probably going to approve this nominee, and it's probably going to fall along party lines. So,
all right, Joe. I think Joe dropped his phone.
Yeah,
Joe, are you there?
But yeah, I thought it was certainly something that was interesting to hear from Senator Graham, and then Whitehouse, and we're in an environment now where people are just sort of acknowledging that, but it still is important for each senator. I mean, for the historical record, and also they have this opportunity to sit down and be able to ask her questions one-on-one and talk not only about her past decisions, but about her judicial philosophy, or as you saw with Senator Whitehouse yesterday, to lay out systemic issues that he has with dark money going into this confirmation process. I think it was effective. And you talked about earlier, well, the cynical view may be that there are some campaign moments here for these senators, but certainly it's an opportunity to speak not only to Judge Barrett, but also to the nation about these really important topics as we consider a nominee here.
Any surprises? I mean, what was that one surprising thing that happened from this day 3 for you, Joe?
I think the fact that the Houston Astros were brought up.
Yep, good point.
was a bit surprising. I thought it was a little bit of a surprise to me that there was such a focus from Republicans today on health care, because that is an expressly political issue at this point, although that the case with the Affordable Care Act is coming up. But you heard Ted Cruz talk about it again. Lindsey Graham talked about that as well. And so we certainly knew and expected coming in that was going to be something that Democrats wanted to focus heavily on. I wasn't sure how much attention Republican senators were going to give that, simply because if they acknowledge it, it is giving it more attention and maybe breathing life into it. They were talking about alternatives and about issues with the Affordable Care Act that they have had. So that, in a way they were saying, look, you're not supposed to Judge Barrett on a case that, it bring up these hypothetical issues, and Democrats are focusing on health care. And oh, by the way, we also have issues with the current health care law. So I thought that was a little surprising. I mean, not a shock, but, there's clearly now strategy involving health care on both sides of the aisle as we go through this confirmation process.
Well, along with the ACA, still a very strong topic today on day 3. A lot of discussion about recusal still as well. And you heard Senator Leahy talk about asking her whether, if anyone is above the law.
We can go ahead. Yeah, if you want to come through, we're gonna end this.
Oh.
Guys, I'm gonna go because Senator Whitehouse is joining us now, so we're gonna wrap that interview here. I can hop back on the call afterwards.
All right, Joe Khalil reporting for us. Joe has got to go speak with a senator.
I think he said Senator Whitehouse is going to have an interview with him.
So looking over our shoulder, still kind of waiting for what is happening. If you're just now joining us on NewsNation Now and the NewsNation Now Facebook page, a little bit of technical difficulties in the Senate committee room. This is the confirmation hearing for Judge Amy Coney Barrett to be a justice on the Supreme Court. This is day number 3 of what we believe will be 4 days. Tomorrow could be the vote inside the committee room, which would then send it to the full Senate, likely to happen later this month. Right now, the Senate has a 53-47 majority for Republicans. So the thought process, and from what I saw, G, even from the Democrats in the room, they know that this is going to go through.
There really is no political, recourse that Democrats have at this time. And I thought one other interesting point I wanted to make before we also take a break is we both sort of looked at each other, and when there was a point where she said, I have my own mind. I assure you that I have my own mind, because there were all of these comparisons between the Judge Coney Barrett and her mentor, someone that she clerked for, and sort of reassuring that she isn't necessarily, she might have the same approach towards legal text, but she may reach a different conclusion than her mentor.
All right, as we continue to wait for the audio issues to be fixed inside the Senate room, We're going to take a quick break here on News Nation Now. We will resume as soon as we know when the confirmation hearing for Amy Coney Barrett will resume. So in the meantime, stick by. We'll be right back.